What's going on, family? I'm Douglas Jefferson, Senior Vice President of National African American Gun Association. I'm here with Geneva and Jonathan out here at Redstone in Burbank, California. Today I'm going to talk to you guys a little bit about the new Supreme Court decision that came down yesterday. So if you follow me, we're going to sit down and go a little bit more into detail about it. All right, family, so now that we're seated, we can go a little bit more in depth into what I alluded to earlier. So the Supreme Court ruling in question is New York State Rifle and Pistol Association versus Bruen. This was a landmark ruling that came down from the Supreme Court, and there were two key takeaways that came from that ruling. The first being that it struck down may-issue licensing schemes, and the second being that it establishes text, history, and tradition as a standard of review courts should apply to determine the constitutionality of gun regulations. What that means for you is that if you live in a state like New York or California or New Jersey or a city like Chicago that has these strict licensing schemes, they will have to change the law so that you no longer have to show proper cause above and beyond the normal self-defense needs of the average citizen. So let's talk a little bit more in detail about both of those things. For the may issue licensing scheme, if you're not aware, in New York, when you're applying for a carry permit, you have to provide what New York calls proper cause in order to get that permit. So that means you have to establish some sort of cause above and beyond what the normal self-defense needs are of a citizen. Now, this has been problematic for years because even people that could document cases where they've been victims of violent crime or had credible threats against their lives and their families by criminal gang members, by intimate partners, by anyone that will want to cause harm against them, even those individuals were having issues with getting those permits. So it's really great that that has been alleviated. Now, what this ruling does, it established that the citizen has a right to bear arms in public. Now, before, in 2008, in the DC versus Heller case, we had the right to bear arms that was established, that it exists inside the home, but there was no commentary on what it meant as far as being outside your home. Now we know via the Supreme Court that that right does extend outside the home, and any type of regulations that would abridge that are going to be found unconstitutional. Now we move on to the second piece, which was a little bit more complicated. So it said, establish text, history, and tradition as a standard of review courts should apply to determine the constitutionality of gun regulations. So the standard, that standard being applied now is a standard that is applied to all other Bill of Rights guarantees. And this is excellent because for a long time, the Second Amendment was treated somewhat as a second-class right. In fact, Clarence Thomas, the justice that wrote the majority opinion, he said this, and I quote, "The constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. We know no other constitutional right that an individual may exercise only after demonstrating to government officers some special need." So now we are going to be able to have that right looked at in the same light as the First Amendment, the Fourth Amendment, many other constitutional amendments that we need and use on an everyday basis to make sure that we're fully enfranchised citizens in these United States. So what this does, this also opens up the door to challenges of a number of other gun control measures out there, such as assault weapon bans, magazine bans, handgun rosters, magazine capacity restrictions, and bump stock bans. So this is really a new day in the Second Amendment, and this is just a great time for us to really take this momentum and move it forward. So what does that mean for us as African Americans? So as African Americans, particularly as members of NAAGA, we want to take this momentum and make sure that we can continue to spread this right, this freedom throughout the community. So what are some things that we can do? We need to make sure that if we aren't involved in Second Amendment activities, we go ahead and start becoming involved. Make sure we reach out to friends and family who may have shown interest in Second Amendment activities, may have shown interest in going to the rank, but they just never took that next step. We want to make sure that if we're not involved in the local NAAGA chapter, we become involved. And if there's not a local chapter close to us or available to us, we reach out to NAAGA to make sure that we can establish a chapter, find out what that process is, and we get that going. We start connecting in our communities, connecting with our civic organizations and knowing who our representatives are. we start communicating to them that Second Amendment rights are important to us, and therefore we want to see law and policy that supports and protects those rights for us. So let's make sure we don't waste this great opportunity that's been given to us by the Supreme Court. Let's make sure we do what we need to do to make sure this right is protected for us and our children. All right, that's all I got for today, guys. Thanks a lot for spending this time with me, and I hope this has been helpful to you. So when you get a chance, if you haven't already, continue to subscribe to our social media, Instagram, Facebook, Twitter, and just look for NAAGA. We'll be out there. Thanks a lot to the Redstone team for allowing me to be out here, and I'm going to catch up with you guys later. Thanks.
Redstone is the shit.